Honorable President, sir, with your permission, can we start today's program? Yes. Thank you. A very good afternoon to all present here and virtually from our ITAT benches pan-India. We have gathered here for an awareness and training program on the Posh Act pertaining to workplace sexual harassment. The workplace sexual harassment in India was for the first time recognized by the Honorable Supreme Court of India in its landmark judgment of Vishaka versus State of Rajasthan, known as Vishaka Judgment, wherein the Supreme Court framed certain guidelines and issued directions to the Union of India to enact an appropriate law to combat with workplace sexual harassment. The Prevention of Sexual Harassment, that is the Posh Act 2013, officially termed as the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013, has been enacted with the objective of preventing and protecting women against workplace sexual harassment and to ensure effective redressal of complaints of sexual harassment. The purpose of this training is to upskill the members of the internal committee constituted under the Act on the subject and to sensitize employees on the issues and its implications at workplace. Now, I request all the dignitaries to please come forward and light the lamp of enlightenment. I request all the dignitaries to proceed to the dais. I request Srimati Beena Pillai, Honorable Judicial Member and Chairperson of the Internal Committee, to deliver the welcome address.
Good afternoon to everyone present here and all the participants present virtually through the YouTube from the ITT benches pan-India. It is an honor for all of us to have amongst us today as Chief Guest Honorable Justice Mridula R. Bhatkar, former Judge Bombay High Court and Chairperson Maharashtra Administrative Tribunal. We thank you, ma'am, for gracing this occasion. It is an inspiration for many to have amongst us Honorable Justice M.R. Bhatkar, as the accomplishments achieved by her are not an easy task. I also welcome Advocate Varsha Bhogle, partner at DB Legal, and which specializes in sexual assault cases and crime against women and children. On behalf of the entire ITAT family, I welcome Honorable Chief Guest and the guest speaker. A warm welcome to all the participants pan-India present here to grab this opportunity to be informed about the issues, statutes relating to Posh Act 2013, its implementations, and the ripple effect from the renowned speakers today. Thank you.
Thanks, Madam. I request our Honorable President to present bouquet and memento to our Chief Guest, Honorable Justice Srimati M.R. Bhatkar. Thank you, sir. I request Srimati Beena Pillai, Judicial Member and Chairman of the Internal Committee, to present bouquet to Advocate Srimati Varsha Bogle. I request Srimati Beena Pillai, Judicial Member and Chairman of the Internal Committee, to present bouquet to Advocate Srimati Varsha Bogle. Thank you, ma'am. Our first speaker for today is Advocate Varsha Bogle. Advocate Varsha Bogle is a graduate from Government Law College, University of Mumbai, and holds degree in legal science and a law degree. She has been certified to be a Master of Law in Commercial and Corporate Law from Queen Mary University of London. Madam Varsha is a partner at DB Law Associates. She is a part-time professor at Government Law College, Mumbai. She has experience in appearing before High Court, DRT, Bombay City Civil Court, Special Court, Session Court, Magistrate Court in various matters related to sexual offense, corporate frauds, white-collar crimes, matrimonial issues, domestic violence, etc. With this brief discussion, may I call upon Srimati Varsha Bogle to address this august gathering on the legal aspects of POSH.
A safe workplace is every woman's legal right. Sexual harassment at the workplace is real, is very much real, and ensues to a much larger extent than what is known of and what is acknowledged. Sexual harassment against women is a violence against women because it is essentially discriminatory and exploitative to women. When a woman is sexually harassed at work, her fundamental rights are infringed upon because her right to life, her right to lead a dignified life, and her right to earn livelihood is affected. Now, the Posh Act was enacted for the first time pursuant to the Honorable Supreme Court issuing the Vishaka guidelines, which came into existence when a petition was filed, Vishaka and others versus State of Rajasthan, which was due to the heinous gang rape of a social worker, a female social worker, Bhavri Devi. Now, after the Posh Act, it is now mandatory for every employer to provide an effective redressal mechanism for each and every female employee who is a victim of sexual harassment at the workplace. So basically now, due to the Posh Act, there is a great responsibility cast on the shoulders of every employer to resolve issues and cases of sexual harassment within a time-bound manner. Because when sexual harassment at the workplace occurs, Article 14, 15, 19, and 21 of the Indian Constitution are infringed because that is your infringement of your fundamental rights. Now, interestingly enough though, the Honorable Supreme Court recognized violation of women's fundamental rights, recognized sexual harassment at the workplace as violation of human rights for the first time within the Vishaka guidelines. So now, with our Posh Act in place, for the first time, India is one of the nations of the world which has a centralized legislation to combat the epidemic of sexual harassment at the workplace. So the roots of sexual harassment are there in the seeds of patriarchy, which basically rests in the delusion that men are superior to women. So what men, and I'm not talking about all men, I'm talking about the not so evolved men, when they feel that there is some sort of harmless flirting or some actions of theirs which is harmless flirting, and certain acts of theirs women ought to enjoy. But that is not the case, because sexual harassment at workplace is a form of violence, howsoever indirect it may be, and any form of violence or harassment nobody enjoys. So on the contrary to what is perceived, no women is enjoying it, and it is a form of harassment. Sexual harassment at the workplace is like a cancer which erodes the psychological as well as physical well-being of women, because it affects a woman's right to livelihood, it affects her efficiency, it affects her concentration, and it overall impacts her in a negative manner. Again, it is embedded in the deep-rooted socio-cultural norms which are prevalent, which rest in male hierarchy. So what happens, this refers to nothing but victim shaming, where the onus shifts from the perpetrator, the wrongdoer, to the female victim. Now, this movement of prevention of sexual harassment at workplace, although it gained momentum pursuant to the Me Too movement, which began in the 2018, still very much so, there are a number of female employees, a number of female victims who do not come and report these crimes, who do not make complaints. And why is that? There are a number of reasons. The first and foremost reason is fear of consequences, fear of the perpetrators. Because most often than not, the perpetrator is somebody who is her immediate boss. He is in a higher position or he's closer to the CEO. He is in a much higher position to her in the organization. There is that. There is fear of stigma, loss of livelihood, loss of reputation, and due to all these factors, the woman is always hesitant. So this is again based on that male prototype, the concept of there being male dominance, and one cannot effectively combat or eradicate sexual harassment at the workplace until and unless we get rid of this whole male hierarchy. So workplace sexual harassment, like I said, is a form of violence, and hence it cannot be called as harmless. It is not just a law which is pro-women, because it is something which impacts the nation. Because it's not the question of male versus females, it is not a gender versus gender. We're discussing, females are male counterparts. We're discussing the whole population. So where if I am going to work and I am reporting to my immediate boss, or I am been assigned a particular task and I am carrying it forward, as a female, I need to be made to feel secure, not worried about how my male counterpart or my colleague is perceiving me. If I am giving a presentation, my mind and my focus should be on the presentation, not thinking that my male counterpart or colleague, who is also in line with me doing the same, is perceiving me in a different way, is seeing my outfit in a particular way, is seeing the lipstick or the makeup, and I'm being objectified. I need to be treated as a human with a brain, with a caliber, as an equal counterpart. So until and unless we don't enforce or go by the provisions which are there in the Posh Act, what will happen is it is not one section of females. Females are half the population. So what happens is when we are saying we are not enforcing the Posh Act, the whole nation suffers. Because if females have that restriction when they're trying to perform their level best, when they're trying to go ahead, if they have to see to all of these things, if they are not able to, because what happens to a male? He goes to work, he is working the late hours, he is not thinking of all these things. So definitely female efficiency is affected, their representation is affected, they are held back, and because of that they are not there in the race for promotions, and hence economic representation cannot be there. So therefore, this law has to be enforced and respected for all-around economic development of the nation. Now, as I said, the objectives enshrined or enumerated under the Posh Act cannot be achieved unless each and every employer or each and every organization in India provides a safe and secure environment, working environment or workspace for women. The objective of the Posh Act is preventive, not penal, which means to say we are trying to prevent sexual harassment at the workplace. We are not, the focus of the act is not penalizing or providing punishment. Most often than not, what Meena madam also told me, let us discuss how the act is misused, because there is a gray area. What conduct or what behaviors account as or are included within the purview of sexual harassment and which are not. We will get there, because what happens is most of the times even the victims are not aware of what that they have been subject to sexual harassment. Even the perpetrators are not aware, because certain, as I said, because if there's a male hierarchy pattern, there are certain behaviors which generationally men are seeing it being done, but that is actually not acceptable, and that comes within the purview of sexual harassment. So let us address what that is. Now, to understand this, first let us see the definition of sexual harassment. Like in most acts, the section 2 deals with the definition clause, and sexual harassment is defined. We have wonderful legislations in place in India, and if you go by the letter of the law and if you are careful enough, you will know that what acts are sexual harassment in this case. Okay, so let us see for the act what sexual harassment says. Again, in addition to this definition, there are other safeguards for all those men who are worried that, I may be falsely roped or wrongly roped into sexual harassment, or there may be concerns, even for women. How do I know that so-and-so is happening? I have been a victim of sexual harassment. In addition to the definition of sexual harassment, there are other guidelines, and I will come to it. But first, let us go to the definition. Sexual harassment at workplace includes any one or more unwelcome acts or behavior. Now, the phrase unwelcome acts or behavior are of key importance, okay, such as physical contact or advances, a demand or request for sexual favors, making sexually colored remarks, showing pornography, and any other unwelcome physical, verbal, or non-verbal conduct of a sexual nature. So as I said, unwelcome behaviors or acts. What is unwelcome? Which means you have to read the room. Unwelcome, as the word suggests, it is where it is one-sided, where it is not reciprocated any sort of action or words by the perpetrator which are invading, which are demeaning. What is the test of what a behavior is unwelcome or conduct is unwelcome? Where the other person is not reciprocating, the other person is not on the same page as you, okay? We will come more to it. So sexual harassment affects a victim personally as well as professionally, and I will, at the end of my talk, tell you how of a case which I have dealt with where it has affected and impacted an employee in a personal capacity. Let us see how it affects you on a personal level. So when a woman is a victim of sexual harassment at the workplace, she suffers from depression, she suffers from anxiety, panic attacks, stress, trauma. She either has weight loss, weight increase, she feels betrayed, she feels negative, and it also affects her intimacy, and she has trust issues even in her personal relationships. That also affects her and impacts her greatly. Her confidence is affected, she has low self-esteem, she has self-blame, guilt, all of these things she feels on a personal level. Now let us move to how a woman is impacted on a professional level. So on a professional level, a victim of sexual harassment at workplace has decreased performance at work. She has absenteeism. She feels depressed. She feels that everybody is watching me, because what happens is it becomes a topic or a gossip in the office environment and in the office group. Everybody knows. She feels like she's been watched. She feels like she's been subject to public scrutiny. She feels like she's being defamed. And what happens is, ultimately, the worst case scenario is she weans off and she leaves the workplace. Now, let us see what an aggrieved woman is for the purpose of this act. An aggrieved woman is basically any female employee by whatsoever name she may be called. She could be an ad hoc employee, a daily wager, a temporary wager. She could be a probationer, a trainee, an apprentice. So she could be on a salary, or she could be working pro bono as an intern. Any female who is working is an aggrieved woman for the purpose of the act. Now let us see what an employer is for the purpose of the applicability and application of this act. Basically, an employer is anybody who has 10 or more employees. It includes all government organizations or not all non-governmental organizations, all trusts, societies, educational institutions, entertainment, all production, sales, supply, all associations and organizations having staff up to 10 employees and upwards. The Honorable Supreme Court has cast a big responsibility on all employers, all such employers, to understand this situation and to protect and provide a safe and secure environment for all their employees. So now, essentially, we have understood what sexual harassment at the workplace is. We have understood how it affects women professionally as well as personally. We have even understood who an aggrieved woman is for the purpose of the act, and we have seen who the employer is. Yes, so Now the constitution of the ICC, the act provides that there has to be a committee to deal with these complaints, to take cognizance of these complaints. It is usually headed by the senior most female employee in the organization. More than half of the constitution of this ICC committee has to be females. There have to be 2 women who are proficient in law pertaining to women, particularly who are sympathetic, who are feminists in a way, and who are passionate for the cause. Okay, simply delegating the issue or putting your HR there is not going to make the cut, because in most cases, it would not be wrong to believe or to conclude that the HR would not focus on a more justice-oriented approach. HR would focus on a more neutral approach, and it would be appeasing or favoring. Naturally, you cannot outrule the bias. The HR would go on a company-favoring kind of judgment. And any law, when you are supposed to enforce it, we have to see that there is justice, equity, and good conscience. When you have your own insider and HR, one cannot possibly presume that justice will be done. Therefore, we need legal experts and somebody impartial from the outside. Now, Section 9 of the Act talks about the responsibilities of the employer. Okay, so the employer, now how do we understand what sexual harassment at the workplace is? We know why it is wrong. It is a cancer which erodes at the physical as well as psychological well-being of the female employees. Let us see what responsibility the employers have. There has to be a strong internal policy or a code of conduct in place. This usually can be like a handbook. When an employment agreement or when a person is employed, that code of conduct has to be circulated, and a copy of that has to be provided to whosoever employee. There has to be at a conspicuous place in the organization a notice put up. So again, this is coming back to when I mentioned earlier in my talk, what is sexual harassment? People want to know, or the so-called men want to say that we didn't know this was sexual harassment. The ignorance of law is no excuse. The Act is telling you, the Section 2 is telling you what the definition is. Second thing is, on the conspicuous place, all the acts are going to be enumerated. These so-and-so acts are amounting to sexual harassment. In addition to this, for a deterrent, for a deterrent effect, the IPC, now BNS, penal provisions, basically the punishments to do those acts. Because what happens is, sometimes certain acts are shown. So-and-so acts are amounting to sexual harassment, sending sexually colored messages, dialogues, making unwelcome passes or gestures, but sometimes that is not enough. We need a deterrent effect, we need the penal provision, so that is also provided. Then the third thing is to provide a complaint box at a place in the organization. So what is this? Because the importance of having a complaint box is, there is an anonymous complaint box that is a safe space, so any woman can make her, write her complaint and put it in there. Okay, then what else are the duties of the employers? To see to it that there is propriety and proper procedure followed in receiving the complaints, that the investigation happens in a time-bound manner, hearings happen in a time-bound manner, there are proper interim reliefs, and again, this is something which is going to reassure the men or make them feel good. The employer also has to take cognizance if there are false complaints of the Posh Act, in the Posh Act put, and accordingly, steps have to be taken against the victim. Even when it is found that a case is genuine, the extent the woman suffers, those factors are to be considered while deciding the punishment for the male accused. And even if there is a false complaint, whatsoever he has suffered, that has to be considered while providing punishment or dealing with the women's case. Now, the Act also casts a responsibility on the employer to have certain seminars of the ICC, to have workshops for the employees, and at the end of the year, annually, you have to report to the district officer. You have to tell the district officer the amount of seminars had, whether the amount of complaints of sexual harassment at workplace in the year, and if certain case has exceeded more than 90 days, the reasons of that have to be recorded. So whosoever employee who does not comply with this guidelines given under the Posh Act, that employer is fined for rupees 50,000. If there is successive conviction, that fine is doubled. And in certain cases, the court also has the right to cancel, revoke, and suspend the license of that employer. Now, coming to the queries part of it, so now that I finished the orientation on law part, Madam has asked me that how can one decipher then what act or what behavior comes under sexual harassment. Now, this is something of interest to all men and women. As I mentioned, if you see, the plain reading of the section tells you what sexual harassment is, so nobody can claim that I did not know. In addition to that, at your conspicuous place in the organization, all those acts are going to be put. So it does not get more clearer than that. Now I will tell you, now coming to my cases. So there was this one case which I would share with you all of an airlines. So this was a pilot. He is a captain now, and he has been in the aviation sector for 30 plus years. He trained a female pilot to fly the planes, and the background of this the female pilot is that she is an engineer by profession, and she's also a qualified pilot. Now what happens is, this 30 plus pilot having 30 plus years of experience, he is arguably or factually within the age group of 45 to 50 years. So what happens is, he's a bachelor. He gave a marriage proposal with bona fide intentions to this young lady, single young lady, as single as he was, through a senior female captain in the same organization. Now, coincidentally, as a matter of fact, this female senior pilot, she happens to be on the Posh committee. And fortunately for this man, for this gentleman pilot, he did not directly message her. There was no direct contact, but he did it through this female pilot. And once the message went to, and so now the factual scenario is, the male pilot is in one part of the state. The female lady who he sent a marriage proposal to, she's in a different part. She is now saying, how could he do that? I have lost my sleep. I am disturbed. It is unethical. He's so much older to me. And now she tried to initiate Posh proceedings against him. So what happens is, now men fear, with the Posh Act looming over our heads, how can you socialize with your female colleagues? That notion is there, काही म्हटलं हिला बाहेर विचारलं फिरायला जाऊया हे करूया बापरे Posh, what is the way out? So you have to read the room. Like what I said, you have to literally read the room. Fortunately, in the case of this gentleman, nothing can prevent this girl from going ahead, because the laws are like that. Just not just the Posh, even when you have to register offense against somebody, the laws are such that, and if you weigh the pros and cons, it is better that it is that way in females. And in case there is a fake case, the evidence will point it out and the male will come out of it. So I'm not getting into that part. I'm just going into the smaller part of the Posh Act. In case this lady, her case goes, but ultimately it would be, what would come out of this? That no direct evidence. Basically, what is to consider in this? Sexual harassment at workplace. We need to, when you deal with offenses of this sort of nature, you have to examine the circumstances of the parties. The girl was not somebody in the medieval period. She was not with all due respect, not somebody who's done 12th or BA or BCom. With due respect, she's done her engineering. She's done her professional commercial training as a pilot. And in the male-dominated world, which it is, she's done all of that. So such a lady who has received a proposal, that too no direct communication, not through WhatsApp, by a senior pilot. And now luckily, both of them are, what does the law say? Both of them are major. She is above 18, he is definitely above 18, so this cannot be a case of sexual harassment. Unfortunately for the poor man, this case did come up, but it was accordingly decided because it was found that he did not do anything. So that is the thing. You have to, so as a male, what is the lesson you take from this? You have to read the room, you have to see if it is reciprocated, and it is a risk you are willing to take. Because I understand males feel, okay, bapre, if I do this, it will snowball into sexual harassment. So you keep your conduct clean and immaculate. Nantar, whatever happens, God forbid, if you find yourself in a fake case, if your evidences are strong and clean, you will come out of it. Another reason why this misuse is happening is, we as a society are becoming very desensitized. People are rampantly using such phrases and such terms like, Bapre, hichabarobar neat bolala paige natar posh lagel. It is not the way. This is now in the context of the Posh Act. There are people who are using rape word also very frequently, and not in the context of rape. They want to say something else, but they're using a heinous, atrocious word like rape just in some other context, just because they want to use a superlative where it is not even applicable. ह्याच्यामुळे काय होते, आपली vocabularies desensitize होते. And because of this, the very serious law which is there for some intention, that is being abused. And that is why when you are using rape, posh and all as a canteen culture, this is what is affecting. Another case I would say is, I would share with you all, is of a female lady boss. They had a love affair, she and her subordinate male, and he said, I'm going to do a posh on you. Now, it is not important to get into what happened over there, but as we know, posh is only for females. So again, that is something we'll have to, but this is one of the cases I have gone through. So he told her that I am going to put posh against you, madam, you have done this, but it is not like all our other offenses. Yes, so as I said, it is very difficult for us to it is very difficult for us as males to go about, considering these are the circumstances, but it is what it is. To be basic guidelines, because this is a small manifestation of what happens in breach of promise to marry or other sexual offenses. You have to be careful. Nantar tumcha unfortunately nashibat ala, you have to keep your conduct clean and your evidence will be there to save you. Yes. A last case of mine, which I would say and conclude my talk on, when I told you it affects the victims personally as well as professionally. So one matter was referred to me by a psychologist, by a therapist. ह्याच्यात काय झालेलं, again she was the victim of, this lady was the victim of sexual harassment. Her boss told her, meet me in the parking lot, cornered her, messaged her beyond the office hours, spoke to her out of context, beyond work. And she was severely impacted, negatively impacted, and she went to therapy. Then her therapist referred her to me. That is another thing what you have to put on your conspicuous place on your notice board. You can show, you have to, another duty of the employer is, in addition to all of this, if you have to guide your employee to seek help from a lawyer or go to the police station or somebody who can actually go, because kya hota, especially if the victim is not a Marathi speaker, like in all cases of FIR, a lot is lost in transition. You are writing something, you are telling the police, usne galat tarike se haath lagaya, but that is not, that definitions of the section is lost, so a lot is lost in transition, and that is why the FIR does not get recorded in the appropriate manner. So you as an employer have to advise, seek help from so-and-so lawyer and so-and-so assistance. So accordingly, coming back to my case, this therapist referred that lady to me. We went to the police station, त्याच्या against गुन्हा नोंदवला, आपण register झाली FIR, all of that happened. But the bitter reality is, त्या मुलीचं लग्न ठरलं, and in all these rounds, because that, her justice was nothing. She was given, promoted, but to some other organization, because the organization could not lose her senior boss, ज्याच्या against complaint नव्हतं, because he was of more value to the organization. So hence the organization sided with the accused, knowing fully that he has done so and so, but they looked at the company's interest. त्याच्यामुळे काय झालं, coming back, we registered the offense against him, but because that girl's, it was a losing battle for her. Every time she went to the police station, she had to do all of that. So finally, because he's a lagna tharla, she said, madam, I will drop it now. There is no point. So this is how the experiences of my cases are. I hope, madam, this is, okay. Yeah, thank you.
Thank you, ma'am, for sharing the information and intricacies of the subject that one should be careful of. May I request our Honorable President to speak a few words on the occasion.
Honorable Srimati Justice M.R. Bhatkar, Chairperson of the Maharashtra Administrative Tribunal, my esteemed colleagues, Complaints Committee, Srimati Kavita Raja Gopal, Member Internal Complaints Committee, Advocate Varsha Bhogle, Vice President and members who are present physically and through virtual mode, members of the staff, and ladies and gentlemen, a very good afternoon to all of you. I do not propose to stand long between you and today's chief guest, because I am virtually sandwiched between two experts. And see, the nuances of the act have already been set out so succinctly set out by Advocate Varsha Bhogle. Thank you, madam. I am happy that we have organized this awareness and training program on this act, and I am told that this is the first program of the kind organized on the subject in the ITAT. The act is a very short act containing about 30 sections, and it is about 11 years old now. The act can be seen as an extension of the fundamental right under Article 14, 15 and 21 of the Constitution of India, because essentially Article 14 frowns at discrimination on the basis of sex, and Article 21, which is the right to life, has been interpreted to mean a life with dignity. It is a matter of common experience that due to the nuclear families these days, and they have also come to stay since long now, women are required to step out of their house in order to augment the earnings of the family. This was not so about 30 years back, because women were confined to their house and only concerned with bringing up children and some kitchen work. But now, because they are a substantial part of the workplaces, both government as well as non-government and private organization, which has essentially resulted into necessity to prevent and protect women from any kind of sexual harassment at the workplace. As it is commonly acknowledged that law is often seen as an instrument of social change. However, it is necessary to note that law itself is not sufficient and cannot be considered as a panacea of all ills. This is because the experience is that although there are prohibitory laws, say consider for instance there are dowry prohibition laws, but dowry days prevention laws, but the dowry dose and dowry has not stopped. So mere provision of some legislation is not enough to achieve the objective of the act. Any legislation in the nature of Prevention of Sexual Harassment Act creates mutual rights and duty relationship. So while it is the right of the woman to be free from any kind of sexual harassment at the workplace, it is the corresponding duty of the co-employees to desist and prevent any such kind of sexual harassment. So essentially, if one of the class which is supposed to follow law, if he abides by his duties, there is no occasion for enforcement of the rights. It is here, I think, where the awareness of the provisions of the Act assumes importance. If you make the respondents in the Act, because they are referred to as respondents as against aggrieved parties, aggrieved person, about aware about their duties while being in the workplace, I think the objective of the Act would be satisfied. So far as implementation of the provisions of the Act are concerned, we have on an institutional level taken steps to constitute internal complaints committee across most of the stations. There are as many as 30 stations in which the tribunal has presence, and steps are also being taken to reconstitute the committees wherever necessary on account of transfers and retirement of members. I think the awareness of the provisions of the Act and a healthy atmosphere at the workplace is the key to achieve the objects of the Act. See, a reference was made to the definition of what is sexual harassment, and it is a very broad definition and subject to interpretation by the courts and the authorities depending upon the exigency of the situation. Because the human nature by itself is so infinite that you can't catch everything in terms of words. So therefore the definition as such is very widely worded. For instance, see the physical contact and advances. Now they can be innocent as well as sexually flavored. Not necessarily all physical contacts may not be sexually flavored. If a lady employee comes, new employee comes and you shake hands, that would also be a physical contact, but not necessarily sexually flavored. Then of course, so the clause 2 is explicitly about demand or request for sexual flavors. Then 3 may be again very explicit about making sexually colored remarks, and 4 also showing pornography. But the 5 then presents a difficulty while interpreting what is unwelcome physical, verbal or non-verbal conduct. And I think the test is what the aggrieved person would think to be unwelcome. That is the test. A particular remark may not be felt to be unwelcome by the aggrieved party. Now, I recollect about one incident which has happened in the court, madam, that one senior advocate was arguing a matter, and he was being opposed by a young lady, beautiful lady advocate, and she was raising some objections during the course of the arguments. And the court then said, asked that lady lawyer that you just wait for your turn, let him finish, and then we will grant you opportunity. The senior advocate, maybe in a lighter vein, said that from such a lady we don't see that these objections are unwelcome, and in fact we are enjoying that. So that was considered to be an unwelcome remark, which was in the context of the gender of the lady. Had it been a male opponent, he would not have said this. So ultimately it is on the interpretation of this act, and as was said, every right is liable to be used and abused. So we have to be very careful. And the one thing is that the gents folk need not feel very unsecure. If you follow your duties, I think there is no damage done. And I hope and trust that today's program will go a long way in achieving the objective of the act. On this occasion, I express my heartfelt gratitude to Honorable Srimati Justice Bhatkar for having accepted our invitation to grace the occasion at a very short notice. I also express my gratitude to Advocate Varsha Bhogle for sparing her valuable time. I may mention that she had come all the way to Nagpur also in the last week only, when we had a training program at Nagpur. Thank you, madam. Thank you very much.
Thank you, sir. Our chief guest to deliver the keynote address today is none other than Honorable Justice Mridula Bhatkar. Justice Mridula Bhatkar graduated in Bachelor of Laws from Pune University and served as judge in the City Civil Court at Mumbai. Madam worked as Registrar General at Bombay High Court and was elevated to be judge of the Bombay High Court on 10 February 2009. She is presently serving as Chairperson, Maharashtra Administrative Tribunal, Mumbai. Justice Mridula Bhatkar was a visiting faculty at ILS Law College, Pune for 2 years from 1990 and 1 year in the Department of Journalism and taught press law from 1999. Justice Mridula Bhatkar was selected to participate in the Gender and Law at the University of Warwick, Coventry, UK, meant for Indian judicial officers. She has been supportive of Me Too movement in India. Justice Mridula Bhatkar has adjudicated in a number of significant cases relating to criminal law in India. She has also adjudicated several notable cases during her tenure as judge, including the Jalgaon rape case, the 2006 Mumbai bombing, and conviction of Gujarat police officers and doctors in the 2002 gang rape, and many more. Justice Bhatkar has also ruled that the provisions of the Indian Penal Code should be interpreted to mean that informed consent does not include consent provided under the influence of intoxicants such as alcohol. Madam has written several articles in Marathi newspapers. She has also authored a book by the name I Must Say This. With this brief introduction, may I request Honorable Justice Mridula Bhatkar to enlighten us on her experiences and share the knowledge on the aspects of Posh Act.
My brother, Justice Badam, dignitaries on the dais, and my dear friends, good evening. Posh is always considered and taken as sometimes it's a fright for the counterpart of the women, that is a males. But we have to always understand and keep it in mind that when we say a woman, it includes man. When we say she, he is always included, and a female carries male with her. So the association of man and a woman should be, it should go together and in everywhere, not only in the family as a husband and wife, but also colleagues or employee-employer, wherever she or he are working. The speakers before me, they have mentioned that Posh is especially it was made under Article 14, 15, and Article 21 of the Constitution. It is a right of a woman to work with dignity, to live with the dignity, and to achieve progress. It is a right. Even under Article 19, that is a fundamental right, Article 19, 1G, every human being, every citizen in India has fundamental right to profess her own occupation, work, and that right is jeopardized if at all the conducive atmosphere is not, woman-friendly atmosphere is not provided to a woman for her, and so her growth can be curtailed. So this is the principle behind this POSH, that now we are aware of it. I remember two cases. I mean, see, this act actually, this Vishakha case, it is in the year 1997. Because Bhauri Devi incident has taken place earlier, who was a social worker in Rajasthan, and she was harassed at workplace. After after Bhauri Devi, Vishakha, in the case of Vishakha, the Supreme Court, where the bench is headed by Justice Sujata Manohar, they laid down a law, they laid down the principles regarding the sexual harassment at workplace. This was I say that this was happening, this used to happen, the harassments used to take place, but the Supreme Court found that this is something, identified it, pointed out that this should not happen. And thus in Vishakha, the directions were given that to have a committee, and these are the seeds of this POSH. But it took nearly 13 years thereafter when the act was enacted. So 1997 was Vishakha, then 2013, I think more than that, 2013 the POSH was enacted. Vishakha, before Vishakha I go to 1981, that is the first all India, all over women conference that was held at Copenhagen, Denmark in 1981. In that conference, some convention was passed, and that is called a CEDAW. That is a convention against eliminating all sorts of discrimination against women. So this CEDAW is the first thing that it said that yes, there is something against the women, discrimination. Sexual harassment at workplace amounts to discrimination, and therefore it is to be curbed out, curtailed. I remember two cases. I would like to quote two cases. One, that was of Rupan Deol Bajaj versus Commissioner Gill, KPS Gill. This incident, I think you may be aware of this particular case, and I don't know how many of you are not aware. If at all you are not aware, I will tell you how many of you are not aware, at least in the audience. You all are aware of the Rupan Deol Bajaj. All right, don't murmur, just feel free to tell. See that IS officer Rupan Deol Bajaj, when there was a party going on or they were all were meeting, many IS and IPS officers were there, and that time IPS officer Mr. Gill, who was a commissioner, he gave a pat on the buttocks of this IS officer lady, Rupan Deol Bajaj. It was in the party. Rupan Deol Bajaj found that it is something outraging modesty of a woman. I am speaking about old section 509 of the Indian Penal Code, but I would like to refer to this particular section because what means the outraging the modesty of a woman was made clear by the Supreme Court in this landmark case. And therefore, we find the place of section 10509 in section 11 of the working of the committee under this POSH, that if at all the committee comes across, then has to report it to the police station, and the offence can be registered under section 509 of the Indian Penal Code. So, as my brother said, what victim thinks is to be considered to know or to arrive at a conclusion whether the offense is committed under or there is a sexual harassment at workplace or anywhere. So ultimately it comes to what? It comes to perception. It is the perception of a woman that whether I am sexually harassed or not, it matters a lot. Varsha she has quoted a case of a pilot and also certain incidents that the perception of a woman should not be always anti-male. The perception should not be immature to assess the behavior pattern of any male colleague or any male person where she is working. See, most of the times we think of women who are working in a corporate offices or of middle class, higher middle class women and their approach towards this sexual harassment. But we have to also think of the majority of women who are working as a laborers, as a mason, or also our household maids. What is their perception? What they think? Sexual harassment and the workplace, if you go read the definition of workplace, even the sexual harassment can take place at home or at any place where there is an employee relationship between a woman and other. When I was sitting here, my brother he just pointed out, and it made me to think over. He said that harassment can take place by a woman also. So a woman can harass a woman, and because there is no specific statement in the act that it should be only at the hands of a man. Like 376 rape, always there is a specific mention of a man, but not in this. And then I realized that as the society becomes complex and the many complex behavioral we come across of the society, then our idea, we come across a different type of people, different norms, different moral values of the changing society, and society is bound to change. So we have also now, it is identified and recognized by the law, you may have women with lesbians or a lay relationship. So these are the complex issues may come before one or the other committee which is required to be formed under Posh, that whether a woman can complain that she's been sexually harassed by a woman, or whether this act will take care of it or it will not. I think that like in the family courts and the family laws like a divorce maintenance, we do come across very complicated questions of law and the facts because of the continuous, and I say very speedy change in the ideas, moral ideas, norms of the society. Our Indian society, we have to also consider and take into account our fabric, the cultural, moral fabric of Indian society. We cannot borrow all the ideas from Western. We have to always see what are our roots, what is the complexion. Just a day before, my one student from ILS college was telling me, Madam, in the new law, they have some diluted the marital rape and all these things. He was talking about it. But that is though it is a different issue, but it comes to ultimately the sexuality of a woman. But the marital rape has come from the Western idea, from the Western society, and still we are not aware whether it can be, how much can be accepted and how much it can be implemented in Indian scenario of Indian family and the structures. It is said that Beti Padhao, Beti Bachao. But we always say that Beta Padhao and Beti Bachao. So, when we say that this Posh Act is enacted with a view to protect women, I always say not to protect, but the act is enacted with a view to respect women. This protectionist approach is not now required, but what is required, the man has to understand that the women working with you, they are the counterparts with having the equal right. They need equal opportunity, equal freedom, and therefore they are to be respected. If women are respected, then automatically any kind of offense or tendency to harass a woman can be minimized. In the case, I would like to refer to the other case. When I was practicing in Pune court, my one client whose case was about maintenance, that is, we call podgi, that maintenance. She had filed against her husband. Her husband was not giving her at all, paying any maintenance. Yet the matter has to stand, the lady has to stand in the box and prove her case. The lady was good, but really from a very downtrodden class. She appeared once, and then what happened thereafter? And there was one more date, I could not go to court, and the lady contacted me immediately in the evening. She told me, she was very scared, she told me, "Madam, you must come to court because I am called by a message was sent to me by a judge that meet me in the chamber." So I went to chamber, and then he told me that your order will be done, but however, we'll go for a tea on some date, on next date or whatever, he told. So she was scared. What I liked, I must tell you, this is a very simple thing. When she told me this, you must be having a question, what I did. I did a simple thing. Next day, I went to the court. I asked that lady to stand outside, sit outside. I went to chamber of the learned magistrate. I went in and I told him that, "Sir, did you say so to a particular lady yesterday?" The color of his face changed. Because you can't sometimes, when there is an offender cannot stand front of if at all confronted with the truth, it is very difficult. First he tried to deny, but then I said that if you want, the lady is sitting outside, I can bring her inside. Then immediately said, "I'm extremely sorry. Please forgive me. My entire career is at stake," and all these things he said. And he said that, "I will never do this again. And I only just liked her and I did it, but I won't do this." We didn't stop there. We took it up, the matter, and then and everything, it happened. It was taken to the logical end. But what is important in this whole incident is that I feel sharing. The woman who was victim or who was there was a wrong demand, sexual demand was made. She came to me and she trusted me and she shared it. The sharing of this kind of incidents amongst yourself, amongst your colleagues, it helps a lot. So sharing should be there, and the women who are the victims, they should not feel that, why should I share? If I share, I will be blamed. This kind of attitude should not be there. This fear should not be there. And therefore, sharing, venting out, it helps the woman to go ahead with the work. Now, on this point, I would just like to, because many of you are working as, I'm told, that the members of the internal committee, some are I'm not aware, but the committee. And so, I quote some observations of the Honorable Supreme Court in Apparel Export Promotion Council versus A.K. Chopra in 1999. And the Supreme Court has said, in a case involving charge of sexual harassment or attempt to sexually molest, the courts are required to examine broader probabilities of a case and not get swayed by insignificant discrepancies or narrow technicalities or dictionary meaning of expression molestation. Here we say the harassment. They must examine the entire material to determine the genuineness of the complaint. The statement of the victim must be appreciated in the background of the entire case, where the evidence of the victim inspires confidence, as is the position in the whatever the said case, the courts are obliged to rely on it. Such cases are required to be dealt with great sensitivity. Sympathy in such cases in favor of the superior officer is wholly misplaced, and mercy has no relevance. So this is what is observed, held by the Honorable Supreme Court, and this is very much applicable in the inquiry conducted in this Posh. As it is mentioned by Varsha also and my brother, that whenever there is an enactment in our society, we don't know how many false cases that enactment will generate. So always, whenever there is a DV Act, which is also in favor of the women, some false cases are always registered. The much criticized and debated provision, that is a 498, that a cruelty, that is also always, that is also many times it is abused. So is the Posh. So Posh, we have to consider only because it is misused many times, and so the enactment is bad. No, it is not. But what is important that we all have to learn, that as women are coming forward, they are getting mixed up with their counterparts, that is males, then this mixing and working together, it is to be looked with a different approach and a proper perception. I say that it is not misused many times. I will use the word that it is many times misunderstood. Sometimes women, they don't understand what is meant by sexual harassment. What is sexual harassment? True that it is to be looked from the angle of the victim, but I'll correct that not always. It is also to be considered from the angle of the wrongdoer, alleged wrongdoer, from which culture he has come, from which, the educational, social strata of both the parties are to be taken into account by the internal committee. Because it is a very important function of the members of the internal committee to have open approach. They should not be biased. We always carry bias and the stereotypes. So unless and until we get rid of the stereotypes about man and woman behavior, man and women working together, we cannot have a correct approach to deal with these matters. So the members of the internal committee, they necessarily should be without bias, without stereotypes, and should be open-minded. They should consider they should have a holistic approach towards what is the position in the society, the social background, upbringing of both the parties. Friends, that's why there is a provision of Section 10 of this Act, Posh Act, and it states, what it says, that it is about the conciliation. So inquiry by the internal committee is necessary, and similarly, the powers of conciliation are also required to be used by the committee members. It is not that whenever there is a mistake or there is an offense or wrong done, it is to be always end in the punishment. It is not that everybody is to be punished. Try to understand. Sometimes there is a misunderstanding. Sometimes there is a very, from a male part, the colleague, there is an appreciation. He says that you look beautiful. Even I go a step ahead, even sometimes a colleague who has come from a different background, he may say and compliment a woman, oh, you have a very good figure. How you take it? You must, I think every woman understands, and she has that we say that an inner sense, intuition, that whether a particular man has said it, what is the intention? The intention of the person matters a lot, and also the perception of a victim. They play vital role in this conciliation process. Many matters can be resolved at the stage of by conciliation. If at all, the committee members, they come across a true repentance or complete misunderstanding by both the parties. So this is required to be kept in mind. That is what I feel. And yes, I'm aware about the Me Too movement, but it is always to be taken with a pinch of salt. It is to be looked into. And what at the end, I will, because see, the topic is such a vast, and I have been dealt with or dealing with these matters on many occasions, and especially now, even I am sitting as a chairperson of Administrative Tribunal. The cases like sexual harassment between the government servants, they do come before the tribunal. And lastly, I will just, my advice, like I said in the beginning, for male, they must respect the women, and similarly, I will tell my all sisters that don't carry your womanhood always. I am always asked a question many times that, did you ever suffer, did you ever come across any gender discrimination, any kind of a different treatment because you are a woman? And I'm very happy and proud to say I have never come across. And I think it is the culture of our Indian society also, that yes, if at all, what I say and what give my suggestion to my sisters or women, that when you go out or when you live, always don't carry your womanhood everywhere. Don't carry the womanhood. Don't have the burden of your womanhood, but try to be human than only a woman. Thank you very much.
Thank you, ma'am, for sharing your experiences and knowledge on the subject. It was an insight to us to know about the nuances of as employee of this organization and member of ICC. I request Srimati Kavita Rajgopal, Honorable Judicial Member and Member of the Internal Committee, to present vote of thanks.
Much has been said about women harassment here. And in short, in legal parlance, we can call it as quid pro quo, this for that. And this normally happens in a working atmosphere. The only thing that I'm concerned is we are still in the awareness phase. Why? Because in 1973, the first incident, at least we came to know about it, was Miss Aruna Shanbag's rape and brutal rape, and where she was... The person was never charged of rape. Yes, ma'am. That is because of that time sodomy was not an offense, and only after that, not falling... She was in coma. Yes, ma'am. She could never say that she was raped. She was raped. And there was no medical. Exactly, ma'am. There was no charge of rape. I yes. Tell this because No, no, ma'am, please.
Protocol, because in Shanbar was, that case was tried by, in Mumbai Sessions Court by Justice, who there after became Justice Jamdar, father of Nitin Jamdar. And in that, I got that judgment. I got it because in 1972 or something, 74 judgment. And I found that the charges were of assault and
Yes,
not
ma'am.
of rape. And then I called the IO because he happened to come before me as a witness in one case. And I asked him, Shivsagar or somebody, that why you did not charge of 376 or whatever. He told me, madam, when she went in coma, we never thought that she will never regain consciousness. And all the nurses who were there, because she was a nurse, they cleaned her. And so there was no medical
Evidence.
examination. And therefore it was not possible to
Charge rape against that, yes, ma'am. I think that the charge was on assault and theft, and he was assault also. Okay. So that was very troubling. That is it happened in 1973, where she had to be in a vegetative state for almost 43 years, where finally the Honorable Supreme Court gave her passive euthanasia for the first time. And though it happens to be a very good thing, but I would say this kind of dreadful things happen, mostly to women, and at least, more sensitively as a sexual offense. So as rightly ma'am had pointed out, this started in 1973, at least we came to know about it. Then again, was in 1992 was the Bavarli Devi's case, where she was gang raped by 5 men. She was a social worker, she was gang raped by 5 men only for the reason that she opposed a child marriage, a child who was 1 year old then. So because she opposed that, she was brutally raped by 5 men. After that, where are we now? We are in 2024, and the Calcutta incident again continues to be in the workplace. So what kind of an atmosphere are we in? At least, we have to be lucky enough to say that we have not come across all this, but that cannot be swayed off, that cannot be, ignored. So like what rightly, as ma'am had pointed out, our existence here should be, we should coexist. But what about our now? We in a phase of existence where we are always in a fear and apprehension of what the other person thinks, what the other person intends to. So as ma'am has rightly pointed out, we are supposed to coexist in this atmosphere, in this environment, in this earth, just like at par with men. And another thing is, like, as Honorable President Sir had pointed out, law has evolved. Law has evolved each time after a very dreadful experience, just like Nirbhaya case. And as ma'am had pointed it out, that time when Aruna Shenbag was raped, sodomy was not an offense of rape. So that was not included in IPC, and therefore he was not charged of rape. Subsequently, it is now part of rape offense. Similarly, what happens is, we should accept that women face harassment, or I should say, even before birth, the determination of sex. And I would not say that till death, it happens even after death. Why after death is that concept of, I don't know how many of us have heard of this necrophile. Necrophile are persons who rape dead bodies. This is not something we just come across in movies or something. There is this offense of Nahari incident, where it is a brutal murder and rape of on dead bodies. So what happened was, in 2018, Karnataka High Court had in fact proposed this to the Honorable Supreme Court, to include rape of a dead body also to be in. But somehow this was not brought about even in the labor code that has come up. Again, I would say that, the most primary thing that Madam has emphasized and what the Act places, it is on and dignity of women. Women come out of the house for a dignified lifestyle, nothing more, nothing less. And so what we all expect is only self-respect and dignity. And as what ma'am had pointed out, this law, this protection that has been given to us should be used as a shield and not as a sword. We have to use it as a shield and not as a weapon to take revenge or for other things. As she had rightly pointed out, we should distinguish what is an offense and what is not an offense. That becomes very important. And again, I would also like to point out the taboo that has been created on women when someone raises this issue. So only on the fear of the taboo that, she is now charging against someone like this. Maybe what she had intended to, we don't know. Maybe because of her dressing, because of the way she speaks, because of her approach, as ma'am had rightly pointed out, it is a taboo that people carry on, because of which not all complaints are being raised, or at least in paper. Again, as you had pointed out, our internal complaints committee will act unbiased, and we will work towards the achievement of the purpose of this act. And ma'am, I should say that in the leadership of our Honorable President, so far we have not got any complaint in our internal complaints committee. And our tribunal being a mother tribunal, I hope we will be a role model for all the other tribunals, and no more complaints, I guess. I'm assuring this. I'm assuring this on behalf of the entire ITAT fraternity. Ma'am, on behalf of our president and on behalf of the entire ITAT organization, I extend my wholehearted gratitude for your valuable time and insight. I also thank Advocate Varsha Bogle for your valuable time and insight on this. Thank you so much. Thank you, ma'am.
Thank you, ma'am. Let us all stand for the national anthem.
जन गण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे